Your Honors, it's a great privilege and honor to appear before you today to address questions of such importance to my country, particularly to the communities of northern Uganda. Excuse me. You've heard from my colleague Boris from the north. I am from the Teso region, but I'll address this court in English. In my brief remarks, Your Honors, I wish to highlight the broader context of these confirmation proceedings and how their outcome could impact on the overreaching process of transitional justice that we have painstakingly built in Uganda for Uganda. Under the Rome Statute and international law, the primary responsibility for investigating crimes committed in Uganda rests entirely with the national authorities. This responsibility aligns with the broader needs of transitional justice, which can only be accomplished by Ugandans themselves. Over the last 20 years, Ugandans have done both. They have investigated the alleged LRA crimes and have also implemented broader reconciliation strategies. Ugandans have done this by passing the International Criminal Act of 2010, which incorporates all the Rome Statute crimes into the domestic law. This followed the establishment of the International Crimes Division of the High Court of Uganda in 2008. Specifically mandated to hear international crimes and terrorism crimes. The ICD recently completed the trial of an LRA commander, Thomas Koyelo, for crimes spanning the LRA's entire period of activity. Victims participated and a substantial reparations order was issued in their favor. In parallel, Ugandans implemented the Amnesty Act of 2000 to facilitate the return and reintegration of lower-level commanders, rather fighters, who surrendered voluntarily, and these include members of Joseph Kony's family. The community, including victim communities, largely support this reintegration, of course, without diminishing the importance of justice and reparations. The National Transitional Justice Bill, now before the Ugandan Parliament, aims to establish a war crimes reparation fund for all victims of the civil war, not just those from specific cases or timeframes. Meanwhile, the reparations award in the case of Dominic Ongwen has created bitterness and disappointment among those who did not qualify as victims, and very high expectations and growing impatience amongst those who did. And this is the context in which these confirmation proceedings are taking place after 20 years of dormancy. This context is highly relevant to the arguments the defense will make in its submissions. But ultimately, this court can only be a small part of the larger project of transitional justice needed to ensure everlasting peace and reconciliation. Of course, the defense's requests not to hold this hearing have since been rejected, and so the proceeding is taking place. These expressions remain relevant so that the people of Uganda can fully understand the context in which these current proceedings are taking place and the position the assigned counsel has taken. From our filings, we have met political leaders, cultural and religious leaders, victim groups, NGOs, judges, lawyers, returnees, and many ordinary people. We've collected their views on the state of the nation, how best to expedite these historical events, their opinions on the ICC, and this process. Unfortunately, Your Honors, the words self-interested and experiment were repeatedly used to describe these proceedings. Ugandans find it hard to understand how these particular in absentia confirmation proceedings serve the interests of their country. A small fraction of these views have, totaling to nearly 100 pages of statements, were presented as testimonials to the pretrial chamber for consideration. The public can access the same on the court's website under filing number 583. Thank you, Your Honors, for your attention. I now take it over to lead counsel.